here's another interesting change, and this is a change from July to November. Well, there we go. In July, we had, in addition to 4 Miranda warnings, we had 4 reasonable beliefs in that version of the proposed rule. And it said you can't even consider undertaking joint representation to 2 or more clients unless you believe 4 things. That got a lot of controversy because, attracted a lot of controversy because, criticism, because how could you know in advance of the representation these reasonable beliefs you had to form? How could you form a reasonable belief with any confidence in advance of knowing what the issues were in the case, knowing the clients and how they relate to one another? Well, so that was controversial, so it got removed from the rule. But it got placed in the comments, so it's still there. And so, the 4 agreed to represent any dual clients, if multiple clients. You should determine that any potential differences among the clients are not so serious that they would be unable to agree among themselves to resolve any material issue that might arise. Yeah, basically the same principle as was in the July version of the rules. How do you know that in advance? Suppose you guessed wrong, that maybe they won't be able to resolve any issue. If the deal goes south and it's in the ditch, you were proved wrong by the facts. And then you have to argue, well, it was reasonable even though I predicted wrong. Also, you have to form this reasonable belief before you even contemplate undertaking the joint representation. These joint clients can understand the issues and can make independent decisions based on the client's best interest. How do you tell that in the initial interview? How do you know what the issues are? Your clients have been sued. You got a petition. Or your clients are going to be sued. You don't know what the defenses are. You don't know what the evidence is. You don't know how the evidence and discovery will develop. How do you decide that reasonably in advance without risk? You'll guess wrong, and you'll be second guessed, and then sued for breach of fiduciary duty because you will have breached your duty under the disciplinary rules. And as you know, fiduciary duty in Texas is informed by the substance of disciplinary rules, and so that's remains a concern. Imputed disqualification again applies in the same sort of issue. Affiliated lawyers and whether you reasonably should know that your partner or associate has a conflict. Let me turn to Rule 109 because that's one of Amon's favorites. Go ahead.
Let me say one thing about 107. The State Bar Board has been sufficiently concerned about 109 that you'll notice in the ballot that you get, I'm in 107, they pull 107 out as a separate rule to vote on. Actually, you've got sets of various rules to vote on. There's 6 different votes to take, but they pull 107 out separately, I think primarily because of their deep concern that what's clearly been the most controversial of all of the votes.
But the problem is, Rule 106, you'll remember, is key to 107. So that's a separate ballot issue, but it's tied in. It all will have to be rewritten if 107 goes out. And a separate ballot issue still is the definitional rule, 1.00, which forms the heart of the concepts that make up both 106 and 107. So those are the first 3 ballot issues. We'll have 1.00, some others, and then 1.06, and then 1.07. 109. 109 is a former client. Rule, key disqualification rule, does retain the substantially related standard for former client conflicts. As Amon said, there was a great effort to abolish that, which would have put us way out of sync with the rest of the country, but that
Eliminated 25 years of precedent.
yeah, has been overcome. However, and Amon, I think, was the first one to really focus on this. Look at comment 7, which creates a new standard different from case law going back to the Supreme Court's Coker decision, 1989, on what is a substantial relationship. And it would transform it from a fact-based inquiry. Was my previous representation were the facts there a lot like the facts here, substantially similar, so that we should be concerned that I'd have confidential information I could use adversely to my former client, a fact-based to a fact and issue-based. Now, is that a lower standard or a higher standard? If I have to show both facts and issues, then my client, my former client, may be out of luck because the facts may be identical. I might be used to it, but the issues are different. That was a probate matter. This is a contract suit. The client's going to be left high and dry if On the other hand, it works the other way, and issues are enough. So we had the same issue back there when I represented the client before, but the facts are totally different, so I wouldn't have any confidential information now that I could use. How does that work? I mean, does that leave me disqualified when there's no risk of confidential use of confidential information adversely?
When you have a motion disqualified filed against you, the court's going to use the Coker standard, the Texas court. You're in the Texas court, you're going to have the Coker standard applied, which says if the facts of the two matters are so related, and the judge has to be able to put in a disqualification order related facts as a part of the disqualification. By adding this in, it's incredibly confusing because there are a couple of cases that talk about facts and issues. And the reason why they talk about issues is because they had both facts and they had the same issues. You have that doesn't occur very often, but occasionally you'll have it. Like Texaco Garcia case had that where the lawyer just switched sides. That's what happened. And so you would have it in that circumstance, but you rarely have that. And so it added this in that creates a confusion with respect to the standard. But I don't think it's probably going to create much of a confusion with the courts, but you're just going to create confusion between you have one standard in the courts and a different standard in the disciplinary.
Except we don't know. Because, I mean, in theory, the courts might say, well, now we've got a new day, and so all this 40 some odd years, 30 years of guidance needs to be thrown out, and we'll look at the rules. And then there's tons of Texas Supreme Court and other Court of Appeals decisions in Texas that say the disciplinary rules provide guidance for the disqualification standards. Well, this is at least new guidance, or lack thereof. Science of defense again, a buddy we get to wrestle with under that rule. And then comment 9 makes a distinction between disciplinary actions and civil actions. And it sounds as if, well, we're recognizing a new day when those are completely different concepts. That's fine if you want to overturn Burrow v. Arce and a bunch of other decisions, the fee forfeiture decisions. But even if you look at the preamble just came out this month. Read the preamble. It is new and it is different than the preamble we have now in important ways. But if you look at the preamble recognizes the courts are using the disciplinary rules more, and it says we don't want to take a position on that. But the comment to a 109 sort of acts like they're completely different standards. And if they're completely different standards, and we're not going to rely upon the disciplinary system, then what the heck are we going to rely upon to inform our concepts of fiduciary duty?
Well, that comment also talks about that in deciding motion to disqualify, the courts will consider the competing interest of the litigants. The courts don't, in a motion to disqualify, they don't consider the competing interest of the litigants. That the competing interest is built into the standard that we have, which are presumptions. That if you have similar facts, then the presumption applies that you got confidential information and it was shared, and you're disqualified. So let me just say this with it. I wish with these rules that they had gotten someone that's completely independent, like John Wiesenkowski at the University of Texas. He refused to ever be an expert witness in a case. He's on the ABA committee that drafts the NPRE exam. He's one of the leading experts. Why in the world didn't you give these rules to someone like that and say, go through these and clean them up, just to make sure you get all the inconsistencies out of them? But my own perspective is that there's such an advocacy approach toward these rules that was never done. It's unfortunate.
And let me actually point out a change. That word consider has now been changed from July to the November version to the word balance. In some ways, I think that's right. They go the other way. And I know it was changed. It's balance to consider. I can't remember which way it went, but in any event, I don't know how you balance or consider given the presumptions we have now. So, confidentiality. New day in confidentiality for you. New definition. The definition is very broad, as our current definition is. It's a different phrasing, but still very broad. All information relating to representation of the client from any source. One of the good things about this change in 105 that I think most of us like is current rule, as you know, has this sort of convoluted distinction between what is privileged, attorney-client privilege, and what is confidential but not privileged. And we wrestle with that. That's abolished in this proposed new rule. However, they create exceptions. So one of the things you'd like to be able to tell your client, most instances, is what's confidential? Is what I'm telling you confidential? That's a pretty baseline, simple, obvious question for clients to ask. You will not know the answer. Because we create two exceptions. The first one is, well, anything that's generally known is not confidential. Okay? What's generally known? Well, the cases don't agree on that. Read the sealed party decision by Judge Nancy Atlas. She lists cases going both ways. Are pleadings in court generally known? Cases say no. Cases say yes. And then we've got this other exception, which is what is readily obtainable from sources generally available to the public, the internet. Okay. So if your client gives you any information and it can be found on the internet, it's not confidential. And if your client gives you information today and it's not on the internet but it is tomorrow, then you lose confidentiality. But websites come and go. They call it website decay. So if a website goes away that has the information, then it becomes confidential again. So the client says, well, is it confidential? Do a search. Tell me what you find at this moment. And that's got a lot of criticism. Nobody has that. That's the unique Texas provision. And some would say we ought to have a brighter line.